Hi, everybody. Hi, Sarah. I think we have everybody. Miss Pearsall, I like your background there.
Thank you.
I see Miss Acevedo. I think everybody else is observing. We've got Miss Garcia. We've got Miss Coffee. I think we're ready. In the 454th Judicial District Court of Medina County, Texas. This is the Child Protection Court of South Texas, and we're streaming from Kendall County, Texas via Zoom and YouTube. Is there any objection from the attorneys to the court holding this hearing from Kendall County?
No, Your Honor.
No, Judge.
All right, very good. With that, then, Ms. Pearsall, would you begin the announcements, and would you let me know who all is here with us today, please?
Yes, Your Honor. Attorney for Priscilla Mejia and Adrian Rosas, and of course, Sarah, the queen of the moment. And we are ready.
And I'm Kim Coffey. I am the current Belong adoption specialist for Sarah.
Rochelle Acevedo, the attorney for Sarah.
All right, and Ms. Garcia, are you just observing?
Yes, Judge.
All right, very good. Then Ms. Coffey, and then Ms. Mejia and Mr. Rosas, would you all please raise your right hands? All right, good. I'm glad Sarah got her hand up too. That's very important. All right, then. Court will take judicial notice of all the documents and cause number 24-. And with that, Ms. Pearsall, you may take it away.
Thank you, Your Honor. Ms. Coffey, can you unmute yourself and introduce yourself?
Yes, I'm Kim Coffey. I'm the current Belong adoption specialist.
Okay. And has this family complied with all of the Belong requirements?
Yes, they have.
Have they passed all the home studies, criminal checks, FBI checks, CPS checks, home studies, updated home studies, and everything else Belongs puts families through?
Yes, ma'am.
And is this child's managing conservator? Have you filed a waiver and consent to this adoption?
Yes, I have.
And do you believe it to be in Sarah's best interests?
I do.
Can you tell the court why?
Yes, so I just got Sarah's case a couple months ago, but I had her previously about a year and a half ago for about a year. And she is in a new home now, and she is doing wonderful. A different child than what I saw a year and a half ago. She has blossomed. The family has been able to meet all her needs. She's extremely happy. She's got cousins there with her. And she's just doing wonderful in the home.
No other questions, Your Honor. Thank you, Ms. Coffey.
Ms. Acevedo?
No question, Judge.
All right, next witness.
I will call Priscilla Mejia.
All right, Ms. Mejia, if you could unmute, please.
Hello, Your Honor.
Good morning.
Morning.
Priscilla, tell us your name.
My name is Priscilla Mejia.
And who are you married to?
Adrian Rosas.
And why are you two here today?
We're here to adopt Sarah.
And how long has Miss Sarah resided in your home?
She's been in our home since August, but she's been in our lives since she was 2 days old.
Name is Mom.
And what are you asking her name to be today?
To Mia Sararo.
And you understand if the court grants us adoption, she'll be yours forever and ever?
Yes.
Including when she becomes a teenager and starts talking back and you're not going to like her anymore.
Yes.
No other questions here.
Ms. Acevedo?
No questions, Judge.
All right, any other witnesses, Ms. Pearsall?
Yes, and I'll call Adrian Rosas.
All right, you may proceed.
Adrian, tell us your full name.
Adrian Martin Rosas.
And are you asking the same thing your wife is requesting?
Yes, ma'am, to adopt Sarah.
Okay. And you're ready to become her daddy forever and ever?
That is correct.
And protect her from every boy that ever tries to date her?
That's also correct.
No other questions here.
Ms. Acevedo?
No questions, Judge.
All right. Any other witnesses, Ms. Pearsall?
No, Your Honor, I rest.
Okay. Ms. Acevedo, anybody?
No witnesses, Judge.
All right, how do you feel about everything?
Judge, I'm in complete support of this adoption. I came in kind of late to the game, but this is one of the quickest adoptions. I mean, they just got on the ball. They got Alana. They got certified. I mean, it was quick. I mean, they are dedicated to her. You can obviously see how happy she is, how thrilled they are. She absolutely found her forever home.
Wonderful. Well, I'm glad to hear it. Anything else anybody wants to add? I think I've heard from everybody that I need to hear from.
Your Honor, I would just like to express my gratitude to Ms. Acevedo. I didn't realize she was ad litem till the last minute because the termination order had a different attorney, and she was really gracious and accommodating with this hearing. So I just want to tell her thank you.
Well, I'm glad. Thank you, Ms. Acevedo. All right, then. Sarah, is there anything you want to add? Is there anything you want to tell the judge?
Is there anything that you want to say to everybody?
What do you say?
This is a good time to ask for ice cream, Sarah.
Yeah, this is when you ask for ice cream or candy or something like that.
You want ice cream?
I want ice cream, Ma.
Yeah.
I want.
You're welcome.
I want.
Say, thank you, Judge. Say, thank you, Judge.
Thank you,
All right, let me make a ruling here, and then we'll get her some ice cream. Okay, the court finds that it has jurisdiction over the subject matter and these parties. Court finds it has jurisdiction over the child of the suit. Court finds that all prerequisites to the adoption have been met and that Sarah is eligible for adoption and that there is no evidence of any other court having any continuing exclusive jurisdiction over her. Court finds that it's in the best interest of this child for her name to be changed to SAS and that it is in the best interest of this child to be adopted. And the court grants the adoption in all respects. Congratulations. You are forever family. We're done with this court and we're going to make it official. Case closed. Time for ice cream.
Yay!
If there's anything anybody wants to say or congratulate the Rosas, you can go ahead and do that now. No, everybody's good? Okay. Well,
I say congratulations. Yeah.
Anyone else? Speak now.
I'm excited to have you officially part of our family.
Aww.
Hi.
Hi.
Thank you, Gabby, for joining.
Okay, Daddy, for the going.
Thank you, everyone.
You're welcome.
Everyone.
Good luck
Thank
to
you,
you.
Thank
Miss
Bye.
Crystal,
Thank you.
I think Miss Sims was still listed on your order since this was kind of a last minute change. So if you want to send me that order with Miss Acevedo on it, I'll sign it and get it back to you.
Will do, Your Honor. Thank you so
All right.
much.
Thank you, everybody. All parties are excused.
Thank
Bye.
you. Congratulations.
Miss Harris, I'd really like to know how, after everything we've done this week, I'm just seeing you for the first time on Thursday.
I don't know, Judge. That's
How is this
crazy.
even possible?
I don't know. I'm feeling a
Because-
little neglected.
The rest of us have been in the trenches all week long. You feel neglected?
Yes, I do.
All right. Well, we'll fix that.
That's scary.
Now you've done it.
And with that, Ms. Kyler Green, would you please begin the announcements?
Good morning. Emily Kyla Green, attorney for the department. Mr. Garcia?
Mark Garcia, Belong, Permanency Case Manager.
Richard Sullivan for the father, Jesse Moreno. He's not present, Judge, but we're ready. He's giving me permission to go forward.
Irene Acosta, attorney ad litem appointed to represent the mother, Monica Johnson. She's present and I'm ready. Ms. Johnson, can you announce for the record, please?
Yes, Monica Johnson. I'm here for Rosalie and Jax. I'm the mother.
Jennifer Harris, attorney ad litem for the children. I'm ready.
Now, if you would all please mute so that we can take up this trial, and then when we need you, we'll unmute you as necessary. Okay. All right. Ms. Kyler Green, you may proceed.
Thank you, Your Honor. The parties in this case, with the exception of the dad, but his attorney was present, have come up with the Rule 11. I've sent out the evidence, so I'd like the exhibits for the petitioner. I can go through them in order if that's okay, and just show them to the court. They've been sent out to the parties previously.
Go ahead.
Your Honor, exhibit number 1 is the CCJ letter for Rosalie. Do you want me to pull these up or just read them out?
Just read them right now.
Yes, sir. The exhibit number 1 is the CCJ for Rosalie. Exhibit 2 is the CCJ for Jax. Exhibit 3, actually, I don't need to do, they're going to be out of order, Your Honor. I'll skip to Exhibit 5.
Okay.
Because we have a presumed father in this case. Exhibit 5 is the service return for the mother. We don't have a service return on the father, Your Honor, but he was present at the status hearing and you took judicial notice of his presence. And then we've got Exhibit 12 is the consolidation order. There was a prior cause number over these children. And then Exhibit 13 is the Rule 11.
And those are the only ones that you want to get in?
That is correct.
1, 2, 5, 6, 12, and 13.
No 6, Your Honor. Just 1, 2, 5, 12, and 13.
No 6. Okay, no family plan of service then.
Correct.
All right, and you're offering these now?
Yes, Your Honor.
Any objection?
No objection.
Then petitioner
No objection.
1, petitioners 1, which is the CCJ letter for Rosalie. Petitioners 2, CCJ letter for Jax. Petitioners 5, which is the return of service on the mother. Petitioners 12 is a consolidation order. Petitioners 13 is the Rule 11 agreement. All are admitted.
Thank you, Your Honor. And if I could pull up Exhibit 13 is Rule 11. Nothing's pulling up. I don't know if someone else has Rule 11 they can pull up because I don't know how long this is going to take.
I don't know if it'll help for you to close Adobe
I got
on your
it.
system. Okay, there you go.
This is the Rule 11, Your Honor. Do you want me to just skip to this?
Please.
Thank you. Would you like, oh, Jesus. Okay. Would you like for me to read it aloud?
Yes, please. Let's read it into the record.
Okay, this is the irrevocable and binding Rule 11 agreement. On March 18, 2024, the parties agreed to the following. Number 1, the parties agreed that this Rule 11 agreement is binding on all parties who have signed, is in the best interest of the children, and is irrevocable. Number 2, the undersigned parties agreed to request the court to name Lisa Mace as the sole managing conservator of the children and to name the parents as possessory conservators of the children. Number 3, the undersigned parties agree to request the court to order that Monica Johnson shall have possession of the children supervised by Lisa Mace as agreed, absent agreement, every second and fourth Saturday for a minimum of 4 hours. Lisa Mace reserves the right to terminate parent-child visitation early if a safety issue to the children arises. Number 4, the undersigned parties agree to request the court to order that Jesse Moreno shall have possession of the children supervised by Lisa Mace as agreed, absent agreement every first and third Saturday for a minimum of 4 hours. Lisa Mace reserves the right to terminate the parent-child visitation early if a safety issue to the children arises. Number 5, the undersigned parties agree to request the court to order that if Lisa Mace is unable or unwilling to supervise the parent's visitation, each parent shall have the right to have their visitation at a supervised visitation center nearest the children's residence at the parent's expense. Number 6, the undersigned parties agree to request the court to order Monica Johnson to pay minimum wage child support beginning May 1st, 2024, and every first of the month thereafter. Number 7, the undersigned parties agree to request the court to order Jesse Moreno to pay minimum wage child support beginning the first day of the first month after his release from incarceration, and then due every first of the month thereafter. Texas Department of Family and Protective Services agrees to waive any child support accumulated during the pendency of this case. Number 9, the undersigned parties agree to the use of their electronic signatures and understand their electronic signature will have the same legal effect as the original signature.
All right.
And Your Honor, I misspoke earlier. I'm sorry. I believe I said that it was Mr. Moreno who was not present, but it was the opposite. But his Ms. Johnson's attorney had the ability to speak with her, but was not able to agree to this, but was present.
Okay. Mr. Saldivar, is that your understanding of the agreement?
Yes, Your Honor. Just for the record, my client is present, and he was present during mediation. We did discuss it. He did give permission.
I saw him come in. I let him in just a few minutes ago while she was reading it. So, okay. Ms. Acosta, is your understanding of the agreement?
Your Honor, my client wasn't present for the agreement. However, in speaking with her since then, she does agree to the terms, save the child support issue, which I was going to address the court regarding.
Okay, let's hang on to that thought for a minute. Ms. Harris, is this your understanding of the agreement?
It is, Judge.
Have you had an opportunity to, I mean, I know you're saying she's going to agree to it except for the child support. Do you believe she understands what it all means?
Yes, Your Honor, I reviewed all of it with her yesterday.
Okay, then let me ask her a few questions. Ms. Johnson, could you please unmute? Is it possible to go to the other one now? Jax. Ms. Johnson, are you unmuted?
Yes, sir. Yes,
I
Your
heard the
Honor.
bird singing again. I should have known.
You'll probably hear the roosters calling.
It's all right. You heard all the terms and conditions except for the child support of the agreement.
Yes, yes, sir.
And notwithstanding the child support, you agreed to all those terms?
Yes.
And you had the opportunity to discuss them with your attorney?
Yes, I was able to discuss them with her yesterday, as a matter of fact.
And you understand what's expected of you?
I do.
Okay. And you entered into this agreement voluntarily?
Yes.
And nobody forced you to do anything, or nobody made any promises to get you to agree to it?
No one has forced me or made any promises.
Okay. Thank you, ma'am. I'm going to put you back on mute. I don't know if there's somebody there that can turn that. There we go. Mr. Moreno, could you please state your name?
Jesse Moreno, Jesse Moreno.
Thank you. Would you please raise your right hand? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Did you hear the agreement when you came in that was being announced as far as how you all are going to move forward with the children?
Yes, sir. I just was told it's like, I guess she's gonna be, the kids are gonna have, Lisa's gonna have custody of my kids, I guess.
Yes. Did you have an opportunity to discuss it with your attorney, Mr. Saldivar?
Yes, I just wanted to get a few more things clarified.
Okay. What is it that you need clarified?
Okay,
Mr. Moreno, can you scoot up closer to the, thank you.
all right, so this is not signing my rights away or anything like that, right? It's just for custody, right?
All right. I can't give you legal advice. All I can do is give you basic answers to your questions.
Judge, if I can get a breakout room for 2 minutes, and I'll
Yeah, we're going to have to do
refresh
that.
the memory.
Otherwise, we're going to be here too long. And we'll go back on the record. Mr. Moreno, so after speaking with your attorney, you understand the agreement?
Yes, sir.
You entered into this agreement voluntarily?
Yes, sir.
You're asking the court to approve it?
Yes, sir.
Nobody forced you into this or made you any promises to get you to agree to it?
No, sir.
Okay, thank you, sir.
Yes, sir.
All right, Miss Mace, same questions. You're a party to this agreement, if not to this case. Are you entering into this agreement voluntarily?
Yes.
Did anybody force you to agree to it or make you any promises to get you to agree to it?
No.
Do you understand what's expected of you?
Yes.
And are you willing and able to fulfill the duties that you have taken on by agreeing to this?
Yes.
All right. Okay. All right, then let's take up the issue of child support. Ms. Acosta, I'll let you go ahead, and since you and your client are contesting it, let me hear from you first.
Your Honor,
Yes.
you had asked me to pull up the consolidation order as well. I don't know if you want to do that before we get into child support, just to get that over with.
Yeah, let's show it to me real quick. Let's take a real quick look. I just want to confirm everything.
Your Honor, because Ms. Johnson makes less than $1,000 every month, the request is that her child support would be based off of income that's less than $1,000.
Okay, and is she, remind me just real quick, we don't have to get into evidence, is she on disability or is she working, or what's the situation?
She's not working right now. She's in the process of applying for disability.
Okay. Response from the parties? Start with the department.
Well, Your Honor, the agreement in the Rule 11 is that we would request it. It wasn't something that the parties were able to come to an agreement on. I think that due to the fact that this is a PMC and PC situation versus an adoption, I think that it's made clear that Ms. Mace is going to need some sort of assistance with the children. I don't know the financial situation in the future for Ms. Johnson, but there does need to be some child support ordered. I certainly don't want to put her in a financially stressful situation. That's not good for anybody, but there needs to be a sufficient amount provided, especially considering the fact that Mr. Moreno is still incarcerated.
Mr. Salazar?
Judge, I'm in agreement with the department on this one. I think the children need support. Mr. Moreno is unfortunately unable to do that at this time because of incarceration. I believe that he's willing to support the children once he's out. So we just ask that mom do the same.
Ms. Harris?
Your Honor, this is an arrangement where the parents were able to keep their parental rights intact, which is what was important to them. And I believe that going along with that is child support. And minimum wage child support is reasonable. The state's found it reasonable. There's no reason it shouldn't be ordered at that.
Okay. What is the minimum wage child support amount that's going to go in your order? Have y'all figured it up yet?
No, sir.
Okay, because if I'm going to render an order, I've got to have the exact amount. So we need to get that. I mean, I think it's the same. And go ahead.
Your Honor, if I may, just for the record, the Texas Family Code does allow for deviation from the standard guidelines if someone does make under $1,000. And if Ms. Johnson isn't working, then her income is essentially zero. So I think that it is proper to order child support according to the under $1,000 a month guideline, which would be $184.70 per month for 2 children.
When you all were talking about this agreement, did you consider medical support?
No, Your Honor, that was not discussed.
Okay. Do either of these parents have any other children that aren't before the court?
Mother does not, Your Honor.
I'd have to ask Mr. Moreno. Mr. Moreno, do you have any other children that are not subject to the suit?
Years old with another ex. Long
I'm
time.
sorry, sorry, you're on mute. Any other children other than these children in the suit?
Not underage.
Okay.
Well, what I'm looking at right here, the minimum wage on the chart for 2024 at 25% would be $289.13. Okay. Ms. Acosta is making the argument, and it is true that the court, the presumption is that guideline child support is in the best interest of the child unless there's evidence submitted to the contrary. Does anybody here negate or argue that Ms. Johnston is making less than $1,000 a month?
I would not argue that, Your Honor. However, I would argue that it is by choice. It is not because of some medical factor that's keeping her from doing this. She does not have disability at this time. She could be and should be working. This grandmother is retired. She lives off of her own Social Security. These children need some additional support. That's why I did not initially support. That's why I did not initially support some kind of joint managing conservatorship or possessory conservatorship, because these children need this assistance.
Okay. Mr. Salazar, any response?
No, Your Honor, I have nothing to the court on that subject.
Okay. Ms. Acosta, do you have any evidence of your client's disability or any evidence that would suggest that she's going to be successful in procuring disability?
I apologize, Judge. I'm here. I do know that she does have a diagnosis that could allow her to recover disability. However, she's currently going through the process. And I also understand that if she does get disability, then the children will be allowed to be covered any child support will be covered for the children.
Ms. Kyler Green, last bite at the apple.
Your Honor, it's kind of been the tenor of this case for the last year that there's been difficulties with Ms. Johnson in pretty much doing anything that's been asked or ordered for her. And I just, she's got 2 kids and her mother's taking care of them and hasn't taken care of them the whole case. I have been and am happy at this point in time that these parents maintain their rights, but I just, there has to be some form of assistance. And, you know, if she wants to get it amended later because she does get put on disability and cannot work a full week or cannot work a full 40-hour week, I don't agree that there's the potential for disability and therefore we don't have child support ordered. I think that's just too much out. I think it's too nebulous.
Okay. All right. I'm out of time and I've heard everything I'm going to hear on it. Then, based on the agreement of the parties, the court will adopt and approve the agreement, the Rule 11 agreement, find that it's in the best interest of the children, and enter a final order, in this case, disposing of all matters. The evidence includes petitioners 12, which was the consolidation order from the prior case. So this court only has evidence in front of it of a prior suit that was already consolidated into this suit, which gives this court continuing exclusive jurisdiction to make this order. The court finds that all parties are present for this final trial and were otherwise duly cited and served and given proper notice. Court finds that it has jurisdiction over the subject matter and the suit as well. And the court finds that the grandmother, Lisa Mace, is to be named as the sole managing conservator of the children, and that the Department of Family Protective Services / Belong is removed as the temporary managing conservator of the parents. Mr. Moreno and Ms. Johnson will both be named as possessory conservators. Ms. Johnson will have possession and access supervised by Ms. Mace as agreed. And in the absence of agreement, it would be the 2nd and 4th Saturday of each month for 4 hours. If then the specific language will be attached to the order in the Rule 11, but the basic order is that if there's a safety concern, that Ms. Mace has the authority to terminate the visitation early. A similar provision exists for Mr. Moreno upon his release. Supervised, and this is all supervised visitation. Supervised visitation on the 1st and 3rd Saturday for 4 hours. Ms. Mace can terminate early if she has safety concerns. And if in either case, Ms. Mace is not available to supervise or can't supervise for some reason, parents will have the option to pay a supervision service for their visit that is in close proximity to the home of the children, not the parent. Having heard no evidence to the contrary and there being no evidence to rebut the presumption that child support is in the best interest of the children, court will order Ms. Johnson to pay minimum wage child support beginning May 1st, 2024 in the amount of minimum wage child support, which is $289.13. Ms. Johnson, the court has to make decisions based on the best interest of the children and the evidence that's presented. If you get disability or something down the road, you can certainly have a court look at that again, but I see no reason for you not to support your children, especially if they're being cared for by Ms. Mace. Court will also order Mr. Moreno to pay minimum wage child support at this time in the order. For it to be enforceable, it's going to say $289.13. However, that's not going to be due and payable until the first day after the first month from incarceration. I don't know when that's going to be. And because you're both being ordered to pay child support for 2 children in the same amount, because again, I don't know when you're going to get out, Mr. Moreno, that's going to be subject to review, depending on the circumstances when you get out. So that might be something you want to look into with the Attorney General after your release.
Sure.
The department waives any accumulated child support throughout the pendency of this case per the agreement. Court will order same. And I don't know how you're going to. The only concern I have is the parties didn't agree to it, and I don't want to go around the parties' agreement. But generally, we order $25 cash medical support for the parents if they're on some sort of governmental assistant health care. Are they? And will they remain on it with Ms. Mace? Because
Yes.
the parents are going to get hit later for, not paying into the health care through the child support. If it's not ordered today, they get away with it. But the fact of the matter is that I really don't want to enter this order without ordering that. So I'm going to order that both parents, as part of their child support, pay $25 a month in cash medical support. Again, mom to begin May 1st, 2024, and on the first of the month payable thereafter for child support and medical support, and Mr. Moreno to begin on the first day of the first month he's released, and child support and medical support paid the first day of every month thereafter. Until the children obviously have there's several graduation provisions and things like that terminate the child support upon reaching the age of majority. So make sure all that language is in the order, please. That'll be the order of the court. There's no further hearings. This is a final order. I'm glad you were all able to come to some sort of agreement. I'm glad the children are able to stay in the family and to have access to their parents. Ms. Johnson and Mr. Moreno, please support Ms. Mace as much as you can, and please pay that child support. If you got to go to work, you got to go to work.
I agree.
That's what we got to do. I mean, if we got to pay child support, I pay a lot for my children. I'm sure everybody else does too. It's just part of having kids. And minimum wage child support is the cheapest child support you can get per the guidelines. So don't let that be a burden or some sort of problem that comes between you and your child's primary caregiver. Get it done.
It won't be
All
a
right.
problem.
Thank you all for your time and your service. Parents, good luck to you. If nothing further, all parties are excused.
Thank you.
Thank you.
All right. I know you said Nate was probably going to be here too, correct?
Yes, Judge, and I would request that we do what we've done in the past, that we start with Sarah's portion, and once we're finished with Sarah, then she's dismissed, and then we begin Nate's.
Okay.
Thank you.
With that, Ms. Kyler Green, would you please begin the announcements?
Good morning, Emily Kyler Green, attorney for the department.
Good morning, Daniela Ramos, caseworker on the case.
Anna Swallow, attorney and guardian ad litem for the children. Ready?
Go ahead, Sarah.
Yes, sir.
You can say your name.
My name is Sarah.
All right. Ms. Ramos and Sarah, if you both please raise your right hand. Thank
Yes.
you. Thank you. Okay, we're here for a permanency review after final order. I had the privilege of getting to talk to Sarah a few weeks ago, and I'm very familiar with what's going on with her. I also reviewed the report. Ms. Ramos, it looks like she's up to date on everything. Her med review's up to date. Her behaviors have been pretty great recently. Educational needs are met. I believe this is the least restrictive placement available. Would you agree with all of that?
Judge, we did get a discharge notice by New Life.
Okay.
So we are seeking placement for her.
When did you get that?
We got it, the last day is going to be next week on the 9th. So we got a 14-day.
Was that right after our hearing, our meeting, Ms. Swallow?
Yeah, shortly thereafter, Judge, it came through.
Okay. So where are we looking?
Judge, I did have a question. I don't know if we're still under the last court order we had as far as placement. So far, I've only received one offer for placement.
When you say the last court order, which specifically are you referring to?
So we did have during the last permanency hearing, we discussed an IPTP program, QRTP, something to that effect. No out-of-state placements, and also the school and campus.
Okay, I'm familiar with all that. I remember that. Ms. Swallow, what's your position on negating or modifying any of that?
No, Judge, I believe that's what we need to be seeking. And if we can't find it, I think we need to, reconvene. But I don't know how much due diligence has been had in order to secure a placement so far. So I can't say that that criteria wouldn't work.
Yeah.
Judge, so as far as IPTPs, we have been denied already, and QRTPs. Foster homes have been denied as well. The only option I have that has been provided to me is a GRO, which is in the Houston area, and the school is not in campus, so they would have to attend public school.
Can I chime in, Judge?
Let me just make sure I got this right. So the only thing you found so far is a QRO or GRO?
A general residential operation, yes.
Outside Houston?
It's, yeah, outside of Houston.
With a school that's off campus?
Correct.
Okay, go ahead, Ms. Swallow.
Sarah has, attending school is one of her, is a concern right now. She's not motivated to go to school. And so I have serious concerns about sending her to an off-campus school. I think school should be on campus for her. I don't know how long the department has been seeking placement, and I would like to know that. If this is just like a few days search, then I think we need to put more into it.
All right. Well, let me cover the basics. Besides this placement issue, which we're going to talk about, everything else that was in your report and everything else I stated remains the same?
Yeah, so medicals, all the, I guess, medical appointments have been up to date.
And you still have her down, what's the permanency goal that you have listed?
Unrelated adoption, Judge.
You still believe that that is in her best interest?
Yes.
I understand that she's going to be moving, but at this time, is her placement the least restricted placement available?
Yes, it is.
However, it's not in her best interest to remain there because of the discharge.
Correct.
Okay. Do you have any questions, Ms. Kyler Green?
Yes, thank you, Your Honor. Ms. Ramos, since the last hearing, what efforts have been made towards this permanency goal of unrelated adoption?
So Sarah is registered on TARE, which is the adoption website for all of Texas and out of state as well. We've had several media segments that she's been featured on. The latest one, I believe, was March of this year.
And what's the concurrent goal?
The concurrent goal is unrelated conservatorship.
Okay, and has Belong reached out to any other family members or fictive kin or any individuals who she has a relationship with?
So the last diligence search was submitted last year, but I can submit another one for this year as well.
Okay, and in regards to unrelated adoption, unrelated conservatorship, are there any individuals who have expressed interest at this time?
Not at this time.
Is the main concern right now getting Sarah stabilized?
That is the main concern. So we are looking into getting her stabilized, and then also looking into families that might be willing to adopt or relatives.
Is she receiving psychotropic medications still?
Yes.
And is that review up to date?
Yes, it is. She just had the last one, the last days of March.
Okay. Thank you, Your Honor. Nothing further.
Ms. Swallow.
Thank you. Ms. Ramos, would you agree with me that it seems that New Life is having some internal staffing issues at this time?
Yes, that's correct.
And that coincides with about the time that they put in notice on Sarah?
I believe they had already been having issues, but more or less.
Okay, well, did not her case manager leave?
Yes.
Okay, and that was about within a week's time that they put in the notice on her.
So she had already gone through 2 caseworkers that had left prior to this.
Okay, but just to clarify, Ms. Ramos, those caseworkers leaving, we're not tying that to Sarah. You're not saying that.
No.
Okay, just want to clarify that. And Sarah was doing really well, was she not?
Yeah, she has been pretty stable for the most part, and she hadn't had any hospitalization since December.
Okay, and have you received incident reports for the incidences that New Life is claiming have led up to her discharge?
I received all the way up to the last days of March 26th.
Could you forward me all those incident reports, please?
Yes.
And what would you say are their main reasons for discharge at this time?
So they did have they initially had another discharge notice back in March, the beginning of March. They mentioned an incident in which she got some medication.
Okay, go ahead. Please continue.
She got some medication from the medication cart. So they ended up writing up an incident report. She did pull her pants down, and that was the reason why they had provided a discharge notice. I ended up talking to them, and they were able to say they were going to give her another chance. And now the discharge notice that we just got, we got it on March 26th, and it basically said the same thing as well as 9 more incident reports.
Okay. Okay.
Sarah, you can put your hand down right now. We'll get to you in a minute, okay?
So, Ms. Ramos, is this facility not the type of facility that is meant to address these types of behaviors?
Yes, it is.
Okay. Your question to the judge, you have to follow the prior orders for placement. What type of placement do you believe Sarah needs?
I believe a residential treatment center.
So before we were looking for something to address her acute psychiatric needs. That's no longer what you're seeking right now, correct?
Well, we did submit a request for that as well, an IPTP program. However, we didn't get any offers back.
Okay. And how long has the department been searching?
Since March 26th, when we received the discharge notice.
I'm sorry, March what
and
date?
I do have 2 people, 26, and I do have 2 people looking for placements.
Have you spoken to New Life about any sort of placement days while the department seeks an appropriate placement for Sarah?
No, I have not.
Is that something you'll be doing?
Yes.
Thank you. I pass the witness.
Any questions, Ms. Carla Green? Can you redirect?
Just a clarification, Mr. Ramos, I don't know if the court was actually able to hear. You said you have two individuals working on finding placement for her?
Yes, I do.
Okay, in addition to yourself?
Well, we don't actually search for placement options. However, I did reach out back to one of the previous placements.
Okay, thank you. Nothing further on.
Ms. Swallow, anything else that you want to ask? Any witness or just report?
Just report, Judge.
Okay, Sarah had her hand up earlier before you go into that. I don't know how you want to handle that.
Judge, I need to talk to Sarah first before she addresses the court in this setting.
Okay. Then do you want to do that at a separate time and then come back to me, or do you want to do that now?
Judge, I can talk to Sarah, and if needed, we can set up another in chambers.
Okay, that's good. All right, good. We're cutting it close on time anyways. Okay, then what else do you have to report? What other requests do you have, Ms. Swallow?
Judge, Sarah was doing amazing. I think her behaviors have improved, in my opinion. I think that she does need some, to continue to work on her emotional regulation and, addressing her mental health needs. But she is actually in a better place than I've ever seen her as far as her state of mind. I think it's unfortunate that New Life has given notice. I think New Life is having some internal issues right now that are having an effect on their ability to meet the needs of their residents. And I think that that's tied directly to the discharge that was given on Sarah. I'm not saying that she did not do things that, rose to the level of needing to submit incident reports. I have not seen all these incident reports. It was quite frustrating to even get Sarah on this hearing today because of their lack of staff. So I just want to make sure the court understands my concerns and that I don't want this to fall solely on Sarah and her behaviors. I think New Life is holding a portion of the responsibility of not being able to meet her needs as well. I would request that the department be ordered to submit, another diligent search as to family, that they also request or inquire about placement days. I'm requesting that we follow the prior orders about no out-of-state education beyond campus, the IPTP or QRTP programs. I can't say a GRO in the Houston area with school not on campus is going to be in Sarah's best interest. I would request that we be ordered to attend the placement team, the people that are making these decisions and doing these searches, that we be ordered to attend a meeting within the next week to discuss all placement options and any potential for anything outside of the box that has not already been ordered, and that we also give the leeway as before, if needed. We can contact the court for an emergency hearing if we need separate orders in regards to her placement.
Okay. All right then. For the purposes of Sarah's permanency review of final order, the court finds that the permanency goal at this time is unrelated to adoption. Court finds that that's in her best interest at this time. Court finds that she's up to date on her medical checkups, dental, vision, and that her med review is up to date as well. She is receiving psychotropic meds. I'll find that replacement at New Life is safe and the least restrictive, but they put a notice, so it's no longer appropriate. It's not in her best interest to remain there, which is unfortunate. I'll find that her educational needs at this time are being met, and that she has been able to express her wants and desires as to placement. Since our last hearing, no other family members or relatives have come forward. I'll find that Belong has made reasonable efforts towards the permanency goal and keeping her on tear and putting her on media segments. She also has, I find she has a concurrent goal of unrelated conservatorship. I do think some orders are necessary. We are going to stay within the parameters of the previous order. I know that's going to make things more difficult, but I agree with Ms. Swallow. When I look at Sarah, I met with her 2 weeks ago. I could tell, and I told her this, that just sitting there with her, I could see a difference in her behavior that I had ever seen before. She's been working hard. It has not been without issue. There's been some issues, but overall, she's improved a lot. And I always remind myself that she's 13 and she's been in this system since she was 5. And there's a lot that goes along with that. So I don't want to shortchange her at all when it comes to finding her the right placement. So I am going to order that Ms. Swallow and Ms. Ramos and Ms. Kyler Green, if you're available, you should go too. But I understand that you're probably going to be involved in other things. But at least Ms. Swallow and Ms. Ramos are ordered to attend the placement team meeting within 7 days. That means that there needs to be a placement team meeting within 7 days. So I'm obviously ordering that too. We need to stay within the parameters of the previous order. I'm going to order Belong in the meantime to keep looking for placements within those parameters and to make sure that we're looking under every rock. I'm also going to order another diligent search, and the request is to the placement days that was requested by Ms. Swallow. I think I've addressed everything as to Sarah. Is there anything that I missed?
Judge, I would just clarify that it's the department, not Belong on this case. It's out of a different region due to prior conflicts. And
You're
also
correct.
For the placement team meeting, I would like the order to reflect that whoever is running the searches or has, decision-making authority, that those individuals be present at that meeting as well.
Granted.
Thank you.
So let's make sure the order says the department, and let's make sure those people are there. And I don't want them, I don't know how this meeting is going to take place, but however the meeting is taking place is how they need to participate. Not available by cell phone if we need to talk to them. I want them there. Someone with decision-making authority and someone who's hands-on. I want it to be a productive meeting of the minds. Okay, well, thank you all on this part for Sarah's case. Sarah, thank you. Talk to your attorney. If you need to talk to me again, we can do that. I'm going to excuse you now. It was nice to see you again, okay?
Nice seeing you. Thank you.
All right, take care.
Bye, Sarah.
Bye, Miss Anna.
Okay, I think the TJ is Nate. Is that correct?
I would believe so.
Yes, sir. That's correct.
Okay, are you able to turn your video on for me there?
Yes, sir.
Thank you, sir. Nice to see you. Okay, so let's talk about Nate. Permanency goal, independent living, correct, Ms. Ramos?
Yes, Judge.
Report reflects he's up to date on his medical, dental, vision checkups.
Yes, yes.
No concerns there.
No.
And then, do you believe that his educational needs are being met?
Yes.
And who's his education decision maker?
I
don't
believe
remember.
myself or Mr. Zamora, who's his case manager there at the placement Pathfinders.
Okay, you believe that that's in his best interest?
Yes.
Okay. And is his placement there, the RTC in Hayes County, the least restrictive placement?
Yes.
And is it safe and appropriate, meeting his needs?
Yes, it is.
Is it in his best interest to continue in that placement at this time?
Yes.
All right. And then what specific reasonable efforts has the department made as far as the permanency goal of independent living?
So, Judge, we do have an appointment for him to get his Texas ID. He does plan on, after he completes high school, which is set for this June, to go to trade school for welding. I am already looking into TLPs, transitional living facilities. I did get a list, and we're gonna look in, because I believe he wants in the Austin area. So I'll look into the ones available in that area.
Okay. Well, it sounds like a good plan. Moving forward.
Some do accept at 17, so he is gonna turn 17 in June. So
Okay.
we should be good.
I imagine the same answer is probably going to apply in Nate's case, but have any other family members or relatives or anybody come forward since our last hearing?
No, he does continue to have contact with his grandfather, however. So that's a family member, I guess.
But nobody's come forward for placement.
As far as placement goes, no.
All right. And do you believe that Nate has had the appropriate opportunity to express his wants and desires as to placement and his permanency goal?
Yes.
Ms. Kyler Green, questions for Ms. Ramos?
No questions, Your Honor. Thank you.
Ms. Swallow?
Thank you. Ms. Ramos, what is Nate's current level of care?
He's at a specialist.
Are you sure it did not drop?
I'm sure. I can
Okay.
double check.
I'm pretty sure I'm moderate.
Okay. In regards to, does he have his social security card?
Yes, so I did get it, and I scheduled the appointment for Texas ID, and it's set for April 18th.
Okay.
So this
And,
month.
okay. And what is your position on him pursuing his driver's license?
I have no issues with that.
Okay. And he needs a social security card in order to pursue that, correct?
Yes, and I believe he's taking already the driver's ed course.
Okay.
He would just need the driving part.
Okay. And so how are you going to deliver that social security card to the facility?
I'm gonna head out there for the appointment because I'm gonna take it myself.
Okay.
So I can provide it.
Okay. Is there a trip next week that Nate would like to attend?
Yeah, so I believe it's on the 10th I already got the approval by the judge.
Okay, great. You got the signed approval.
Yes, I sent it to the facility just this morning.
Okay, and there's another trip coming up in July to go to Alaska. Are you familiar with that trip?
Just by you, I haven't heard from the facility about it,
Okay.
but I'm not opposed to it.
Okay. Once you have those details, will you be drafting another advisement to the court and request for approval?
Yes.
As far as future placements, once he graduates in May and then hopefully is able to go on that trip in July, you're looking for a TLP for him?
Yeah, so I'm already looking into it because I know they take a while and some of them ask for interviews. So I am looking in the ones within the area where he would like. However, if there's none available in that area, I'm still looking in the other ones anyway.
Okay, and are you aware that there is an individual that has offered placement for him?
No.
You're not familiar with the conversation you and I had and the conversation he had with you about an employee where he currently is at that has offered to be placement for him?
Oh, a TLP within that same program?
No, ma'am, I'm not talking about a TLP. I'm talking about a home, like a person's home where someone lives that is offered to be placement for Nate.
Oh, I don't recall. I'm sorry.
Okay. In regards to that, is that something that you will look into?
Yes, I can look into that person.
Okay. And what would the department need in order to look into that person?
So we do run background checks on that person. So I would need their address, identification, and then I would run the background checks, and then we can request a home study, or I can do a walkthrough of the home so that I can do a preliminary home study myself.
Okay. You're aware that Nate wants more normalcy in his life?
He does mention that, yes.
Okay. And is that something you're going to keep in mind while we're searching for placements?
Yes.
Especially during his last year in care, he will already have graduated. He's well on his way to adulthood.
Yes.
So we need to respect that.
Yes.
Okay. Thank you. I pass the witness.
Any redirect?
No, sir. Thank you.
Ms. Swallow?
I am so proud of Nate, Judge. He's done so well. He has pushed forward to this graduation date, which is phenomenal. And, you know, he recently went to Hawaii. That was a great trip. And he has this other trip to Florida, and then he's going to hopefully Alaska. So not only is he enjoying life in regards to travel, but he's working very hard educationally. You know, it seems like he has a really good balance, and he's getting a taste of what it means to be a young adult. And I'm super proud of him for that. I want to make sure that in our efforts to find him placement, that we really keep an open mind. Nate will not do well in an environment that has too many restrictions, especially at this point in his life. I want to be able to respect that and allow him to be in a place that is less restrictive, that still has some structure, but that still that has normalcy. He does not need to be in an RTC type setting anymore after he graduates. So I want to make sure that we keep that in mind. I think that I may be requesting a hearing sooner than our next permanency hearing if there's issues as to his placement. That's all I have, Judge.
Thank you. You know, Nate, when I was reviewing that travel request and signing it for you this morning, there was one thought kept running through my mind. You know what it was? Is there an extra seat on this plane for me? Looks like it's going to be a fun trip.
Yes, sir.
I'm glad you're getting to go.
Thank you.
You're welcome. Anything that you wanted to add, Nate?
No, sir, not really.
Okay. Then, court finds that the permanency goal for Nate is independent living, and that's in his best interest. Court finds that he's up to date on his medical, dental, and vision checkups, that his educational needs are being met, that his education decision maker is either Ms. Ramos or Mr. Zamora there at Pathfinders. That is in his best interest. Court finds that at this time, it's his least restrictive placement, and it's safe and appropriate, meeting his needs, and in his best interest to continue. However, I do agree with Ms. Swallow. I'm going to order the department and the parties to start looking at non-RTC settings for Nate as we move forward in his life. I agree, he's made a lot of progress. He's got a good balance going, and having teenagers at this age, especially sons, I do understand about sometimes the less is more approach, and I want to make sure, again, you have structure, you obey the rules, but that you start getting to live life on your own a little bit more and being trusted a little bit more, so that you can continue to grow into a man and a productive member of society. I want to see that happen for you, and I just want you to be happy. So let's start looking at that as we get closer. He's going to graduate in June. So I want to make sure in order that we get him his Social Security card. I know, Ms. Ramos, you said you were going to take it to him. And I want to order the department to assist him to get his driver's license, because he's going to need that too. So let's be looking at trying to get that done before the summer if we can. And also, if Nate wants to be in the Austin area, if that's where he feels like life is going for him, then let's focus our efforts there as we look toward this non-RTC setting. I'm going to order the department to also look into this person that Ms. Swallow was referring to that Nate knows that may potentially be a placement. Let's get that person's credentials and look at that and see if it's a viable lead. I'll find that the department has made reasonable efforts in setting up the appointments to get Nate's ID and looking at long-term at his graduation plans and the idea that he has to go to trade school for welding and then looking at the TLPs. I know that may not be exactly what happens, but that's the plan, and I'm glad that there's eyes on it. I think we've covered everything. Again, I approved the trip to Florida. I'm really happy to do that. If there's another one to Alaska, even though I'm going to be super jealous, I'll approve that one too, because I want you to get to go do these things. Next hearing would be September the 5th, 2024 at 10:30. September 5th, 2024 at 10:30. And that's for both Nate and Sarah. Yes, ma'am.
Judge, I forgot to mention, I think he would benefit from a follow-up circle of support. I think it's already in the works, but I would like the order to reflect that.
So ordered.
Thank you.
Judge, can I just I'm sorry, I forgot to ask for, can we get an order asking for another psychological on Sarah? Since we just got one in January, but Superior wouldn't pay for another one and the IQ came out low.
I don't have any problem ordering that.
I
think that's appropriate.
Thank you.
So ordered. Okay, then I think we are done. Nate, I know that there had been a mention of possibly talking to me this morning, but it sounds like everything's okay. If you need to meet with me, just let Ms. Swallow know, and she can let Ms. Greenlee know. And I'm happy to take some time when I'm not on a docket and sit down with you for a half hour or however long you need, okay?
Yes, sir. Thank you.
Okay, thank you for being here. I'm glad you participated. Thank you all for your time and your service. I'll see you September 5th, 2024 at 10:30. And I'm looking forward to hearing all about your trips that you're taking. Any objections? Nothing further, all parties are excused.
No objection.
Thank you, Judge.
Thank you. With that, Ms. Kyler Green, would you please begin the announcements?
Emily Kyler Green, attorney for the department.
Christy Canal, permanency supervisor with Belong.
Brianna Bellows, intake specialist with Belong.
Vanessa De Los Santos, permanency specialist with Belong.
Irene Acosta, attorney for Nikisha and Jesus.
All right, Ms. Bellows, let's go through your report. Nikisha at this time is 17. She's in an RTC in Comal County. Jesus is 16. RTC in Harris County. Are both of those placements safe and appropriate, meeting their needs?
At this time, yes.
Are they in their best interest to remain in those placements?
Yes, Your Honor.
Okay. And Nikisha's permanency goal is APLA, independent living. And she is up to date on everything that I can see, no concerns. She's in weekly therapy. Her checkups are up to date, and she's on several medications, but they all most of them seem to be for non-psychotropic reasons, and then she also is on some psychotropic meds. Are all those reviews up to date?
Yes, I would like to note, I received an email, I believe, towards the beginning of this past week from the nurse there at Nikisha's placement. Nikisha has been refusing her medications since March 25th through April 1st. And so she met with whenever they did a med review, and they have decided that they're not going to continue giving her any sort of medications right now since she has refused all medication. They've been closely monitoring her since she has not been on those medications, and they do see that right now she is doing well overall.
Okay. All right. And then you're her education decision maker, and the backup is Ms. Valdetta. Is she receiving all her educational needs? Are they being met?
She is. I would like to make note, as of March 25th, I was no longer her caseworker. Ms. De Los Santos took over the case March 25th as I took on a new position within Belong. And the new supervisor is Ms. Christy Knopp.
Okay. So then we'll switch to you, Ms. De Los Santos. Did you take the oath?
Sorry, I did not.
Okay. Would you please raise your right hand? State your name, please.
Vanessa de los Santos.
Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, ma'am. Now that you're the caseworker, just wanted to ask you some questions about Nikisha as far as her educational needs. Are they being met?
Yes, they are. She is currently passing all her classes except for PE.
Okay. In another case, I've gotten some information that there may be some things going on at New Life. I just want to find out, is Nikisha good there? Is there any plans for her to be moved? Have you received any notices or anything like that?
I haven't received any notices since receiving her case. I did have a visit with her on March 28th, and we talked about placement, and she seemed to be okay there and liking it.
Okay. Well, that's good to hear. I'm glad to hear that. Do you believe that, as far as Nikisha is concerned, that Belong has made all reasonable efforts towards achieving the permanency goal of APLA?
Yes, I do.
And she's got her birth certificate, her social security card, and her driver's license?
Yes, she does.
Okay.
Oh, not her driver's license. I'm not sure.
ID.
Yes, an ID. Yes.
Okay. All right, let's talk about Jesus. Jesus, 16 at this time. Who's best suited to testify as to Jesus? Does it matter?
I mean, I was a caseworker up until the 25th, so I can definitely testify up until that date. And then I've got a little bit of information after the 25th, some emails from placement, but whoever you want to call.
Okay, well, why don't we start with you since you had the most knowledge of the case up to that point. His permanency goal is alternative family unrelated adoption.
Yes.
And he has expressed his desires that he doesn't want to be adopted anymore. Is that correct?
Yes.
So have you all talked about staffing to change the permanency goal?
Yes, I did with my supervisor. And I know it was discussed in our staffing notes when the case was transferred.
What was the result of that discussion?
So the new supervisor and the new permanency specialist will discuss that.
Okay. And he's on tear, tap, and the weekly broadcast?
He is.
Okay. He's up to date on all of his checkups?
Yes. And so to talk about those checkups, that was an email that I received after the 25th, was a dental checkup that he had. And he went, but he refused treatment. He refused like cleaning and stuff and said that he wasn't in the mood to receive that treatment after they got there. So he did not like have his teeth cleaned or anything like that.
Okay. All right. And he's on a few different medications. Ms. De Los Santos, are his medication reviews up to date?
Yes.
All right. And you believe all his educational needs are being met?
Yes, I do.
And he's also got his birth certificate, his social security card, and state ID?
Yes, he does.
Okay. And is it in the best interest of both of these children to remain in the permanent management conservatorship of Belong at this time?
Yes.
Ms. Kyler Green, any questions for either Ms. Bellows or Ms. De Los Santos?
For Ms. De Los Santos, what was the result of the staffing to change the permanency goal?
His permanency goal will be independent living.
Okay. And is he aware of that?
Yes, yes.
And are there any other efforts besides the ones that you've already discussed or that were discussed by Ms. Bellows that will be made to help achieve that goal?
I mean, just keeping in contact, definitely with his family, his older brother and sister.
Is he still seeing Nikisha?
Yes, he is. He just had a visit on March 28th, and their next one is set. There's that. Oh, I'm sorry. What was that?
That's okay. How often are their visits?
I believe they're bi-weekly. The next one is April 11th.
And are those visits still safe and appropriate for each other?
Yes, they are.
Okay. Okay, nothing further, Your Honor. Thank you.
Also,
Yes, thank you, Your Honor. What efforts are being made to engage Jesus in the extracurriculars that he's expressed an interest in?
So with Jesus right now, though, he's actually wanting to move placement. He's talked about wanting to come back closer to his area. He did talk about if he could come back to New Beginnings, which he stated he liked more and was able to do a lot more stuff rather than where he is now.
So is it the placement that's not allowing him to engage in extracurriculars, or is it, what's the issue?
I'm sure what he indicated to me is that he was able to participate in more at New Beginnings than his placement now.
Okay, so it's your testimony that it's the placement that's not facilitating it. Is that correct? And that's why he wants to move?
Yeah, the way he's explaining it. Yeah.
Okay.
Yes.
Has the Belong looked into New Beginnings taking him back, and is that something that is feasible?
she didn't want to answer your question.
I tried to ask it nicely.
Yeah, you did. I don't know if we're going to get her back.
That's all right. I can just address the court, Judge.
Why don't you do it? Go ahead and do that. It looked like she might have been on the road.
Okay. With regard to Jesus, sorry. I mean, he at the placement where he is now, he is closer to his best friend, that he's known for years, which I think is good because that's like a consistent part of his life that he's had following him throughout this case, and that's given him some sense of, I don't want to say permanency, but it's a stable part of his life, along with his siblings. And so, but the placement where he is right now, it also, he's not able to engage in the things that he wants to engage in. So I know that moving back to his old placement, New Beginnings, would allow him to engage in more things, but it'll also put him further away from his best friend. So I think it's kind of a balancing act. And I'm not even sure if they'll take him back at the old placement, but just something to consider. He does want to do more, and he's not able to. And so I think for someone his age, that can be really, really frustrating if they have these endeavors that they think that they should be allowed to do, and they're just not able to do them because of the placement that they're in. With regard to Nikisha, I talked to her supervisor at the placement this morning just to clarify things about her medication, because it had been a couple of weeks since I'd spoken to Nikisha herself. But they did clarify that they're supporting her and not being on the medication because she doesn't want to be on it anymore. He said that she hasn't had any incidents. She seems to be doing really well off of it. But again, that might be something that takes a little while for any adverse
events or reactions from her stopping the medication abruptly. It might take a while for that to be shown. I do have concerns. I know that this is a placement where she's not going to be able to remain there after she remains 18. They don't have any kids there who are over 18. And so I want the transition for her to go smoothly wherever she's going to be after this, because I know that that can be traumatizing in and of itself for a lot of these teens, where they've been in an environment where they have a lot of support and where everything is, there's a lot of oversight, and then they're thrust into adulthood, and it's another event for them. So I would just like more of an update on what that's going to look like. I understand that there's the supported the extended care, but she still has to finish high school because I believe she's about a year behind. And I just want her to have as much support as possible, Judge. It's, she does have contact with her sibling, but the way that her case differs a little bit from Jesus's, I think, is that she doesn't have like a constant best friend who's, she's been in contact with this whole time. She's only had her brother. And so she does regress. Sometimes she does have incidents where, occasionally she self-harms or she has outbursts towards the staff at her placement. But right now she's not having those incidents. And I'm hoping that it doesn't happen again. I know that transitions and things happening that she's not necessarily prepared for can sometimes be triggers for her. And I don't want her to turn 18 and have less support than she needs to be a functional adult. That's all.
Thank you. For the permanency goal for the permanency review hearing, court finds a permanency goal for Nikisha of Apala, and for Jesus at this time, alternative family unrelated adoption is appropriate, but I am going to make finding that there was testimony that Jesus's permanency goal is going to be changed to independent living. I do believe that that's in his best interest. I think we're beyond the adoption scope at this time with him. Court finds they're both up to date on all of their checkups, that their educational needs are being met, receiving therapy and psychotropics as necessary, and those reviews are up to date. Court finds that their visits with each other are appropriate and they should continue, and I do urge those to continue. Court finds they both have had the opportunity to express their wants and desires as to placement. Going to order the parties to have a meeting, call it whatever you want, regarding Jesus and this potential placement change, just to make sure we cross all the T's and dot all the I's, and we don't move him and regret it. I mean, I know nothing's perfect, but more thought that goes into it I think with his involvement is going to be helpful. Court finds that they're, I don't know if I already ruled on the placement. I'll find that they're safe and appropriate, meeting their needs and in their best interest to continue at this time. But court finds that Jesus has expressed a desire to come back closer to his previous placement or back to his previous placement. I agree with Ms. Acosta. I think that the more support we can give them, and I've said this before, these children have been in care since, well, what's our cause number? 2016, so 8 years. It's the second case I've had today where I've had a kid in care or kids in care that have been there for 8 years. So over half their life they've been in care. Well, half of Jesus's life and almost half of Nikisha's life, and it's just they really need our support. They've grown up in the system for the most part, so I want to make sure that anything that we can think of to do for them, we're doing. Ms. Acosta, are there any other specific orders that you were wanting me to make today?
No, Your Honor.
Okay. I'm always available to meet if they want to meet. If you guys need some further orders, whatever it takes, just to make sure that we're sending them out into the world as prepared as they can be, because it's on us. It's our job. They don't have parents doing it for them. It's our job. So thank you all for your time and your service. And if nothing further, all parties are excused. I will see some of you after lunch. Our next hearing, if I didn't say, is September 5th at 11. September 5th, 2024 at 11. Thank you. All parties are excused.
Thank you.
Judge, I talked to him last week and exchanged emails with him, but my expectations run very low.
Okay. I don't think we have everybody that we're going to have. All right. With that, let's get announcements starting with the department. And if each attorney would please prompt any clients present to announce.
Good afternoon, Emily Kyla Green, attorney for the department. Ms. Powell.
I'm a PAL permanency specialist with Belong.
Christy Knott, permanency supervisor with Belong.
Kathleen Savage, attorney for the respondent mother, Tracy Bushman. She's present. Ms. Bushman, if you can unmute and announce your name for the record.
Tracy Bushman, mother of the twins.
Jennifer Harris, attorney and guardian ad litem for the children. I'm ready.
Alana Pearsall for the father who is not present, and I'm not ready.
Jill Roden, Tri-County CASA.
Anna Swallow, representing the interveners, Tristan and Emily Ford. If you could each unmute and state your names, please.
Emily Ford, foster parent of the children.
Tristan Ford, foster parent of the children.
We've got 3 motions set for today. I believe 2 of them are non-evidentiary motions. And then we've got a motion for authorization to place, which might require some evidence. I don't know if the others will or not. Ms. Pearsall has announced not ready. Is it purely by virtue that your client's not here and you haven't had contact with your client?
Your Honor, it's because he's not here. I actually had very recent contact with him, and I provided him both a reminder regarding this court and the Zoom link on April 2nd. But he's not here. Therefore, I'm not.
Okay. Just because we're here, I'll hear some very concise, very brief responses to the not ready, if anybody has one.
Your Honor, he's been previously served in this case, and I don't think any of the permanency options for the children should be placed on hold because he's not a participant in this hearing. And Ms. Pearsall is notified of both motions.
Your Honor, the department has the same position. He has been previously served. He has, I think, yet to show up to a single hearing in this case. So, and the court has consistently moved forward with the permanency hearings throughout.
And my position is the same, Your Honor.
Not ready is overruled. We're going to proceed. Let's start with, we've got a motion for continuance filed by the interveners, but we also have an intervention with a motion to strike. I'm not so much worried about the objections of the associate judge yet. So I think I need to hear the motion to strike first. And that is Ms. Savage's motion. I've reviewed the intervention and reviewed the motion to strike. So if you just want to make arguments, I don't think that we need an hour and a half. I think we're going to be done well before then. So Ms. Savage, if you would, please.
Yes, Your Honor. And I apologize. I have my camera off as my Wi-Fi is not the greatest today. But as the court's well aware of, the court has wide discretion on making rulings in regards to motion to strikes. The primary factor in consideration for the trial court is always what's in the best interest of the child. And there is the parental presumption that a natural parent as a managing conservator is in fact what is in the best interest of children. There's multiple cases in Ray Kell, in Ray Northrup, Oliarch versus Texas Department of Protective Regulatory Services, which all have the same basis that when a motion or when an intervention is filed very closely to a trial date and or dismissal, which we are less than 60 days or right, our dismissal is May 12th. So little over 30 days from our dismissal deadline, that it's been found to be untimely. And that has been supported by a trial court's finding of a basis for striking the intervention. Moreover, there are 3 criteria that a petition to intervene has to meet in order to survive. One, the intervener needs to be able to have brought the same action in their own name. I don't even think the interveners could do that if CPS were not involved, right? So Texas law requires, in order for non-parents to file any kind of request for conservatorship, they need to show that the appointment of a parent as the managing conservator would significantly impair the child's physical or emotional development. We don't have that in this case. The children were placed with Ms. Bushman and subject, but for a housing situation and Ms. Bushman making the decision that her children should be with a former foster placement as opposed to a shelter, they would be back with Ms. Bushman right now. They were not removed for a safety issue. They were not removed because their health was significantly going to be impaired. We've got a mother who's completed all her services. She is not a physical or emotional danger to these children. So I don't think they even satisfy that first prong. But even if the court were to find that, they have to satisfy the second prong, that they will not complicate an excessive multiplication of the issues. They absolutely will. We were looking at a monitored return, but for this intervention, now it's going to be a custody issue. On top of that, we're 30 days outside of dismissal. If this case dismisses, that severely complicates what issues we're looking at. And that would force either an automatic dismissal or potentially not being able to have the actual trial, because we also have the intervener filing an objection to an associate judge, requesting a motion for continuance, filing discovery, things that cannot be done within this 60-day, when they filed, within 60 days of dismissal deadline. So there's that issue as well. Then there's the third criteria where the intervention has to effectively protect the intervener's interest. Here we have ad litem's who prefer the intervener's family. So I don't think that that is an issue that they can, or a burden that they can meet at this time either. So our position is that this intervention is completely untimely. The foster family dropped their license whenever they took these children in back in December. So they're effectively classified as a kinship placement. Their intervention should have been filed back in January, since their basis for the intervention is that they're kinship and they have past significant contact with these children. Waiting until 60 days within the dismissal deadline creates an issue, and it's absolutely untimely. And there are several court case, prior cases and case law that support that the court can strike the intervention based on it being untimely. And we would be requesting that the court do that today, as allowing the intervention to stand will create mass complications. We don't have the time frame before the dismissal. We don't have time to do discovery. We don't have time to get in front of a district court judge, and we don't have the basis for it. We've got a parent that these children should be returned to.
All right. Ms. Kyler Green, response.
Well, Your Honor, I guess I'll start with the department's position. The department is not opposing the intervention, and that hasn't been an easy decision for us to make. I will agree with Ms. Savage that the timing is probably going to prove to be difficult. This case was ordered to mediation, and that's been difficult to schedule already. And adding in the interveners has made that a little bit more difficult. And yes, we are close to the dismissal date in this case. However, I disagree with Ms. Savage's rendition of the first prong, that the placement with the managing or placement with the parent would significantly impair the safety or health of the children. I don't agree that the reason why the return was recanted, the return of the children to Ms. Bushman was the children were taken back. I don't think that can be chalked up to just housing issue. Children who don't have a place to live, that is a significantly dangerous situation for them to be in, especially at the time of that incident. And while Ms. Bushman didn't necessarily fight that issue, because I think she realized she had no place to live with the children, it still was a contested issue that the children were, that the return of the children, was recanted, or retracted. I'm sorry. I think that the technicality of the Fords turning into a fictive kin placement as opposed to a foster placement, that's not that dispositive in the eyes of the department. I think that in regards to when they should have filed or could have filed in this case, I think that for purposes of permanency of these children, we do need them at the table. I think it's important that they do have an attorney who's able to represent their interests, because I think that this foster placement is able to identify the best interests of these children probably better than anyone else in the room. So we overall, we are not in opposition of their intervention.
Ms. Pearsall, do you have a position? Were you able to get one from your client?
Yes, Your Honor, we agree that this intervention is untimely and would make this case much more complicated than it needs to be. That's the point, of the law, is that if it does make it so much more complicated, even if it was timely, even if it met all the other standards, the appellate cases are very clear. Intervention should still be kicked out, and there's no question that at this point, judicial issues as to which judge, which court, the issues of who has custody, which wouldn't even exist, would make this much more complicated than it needs to be. So we are supportive of the motion to strike the intervention.
Ms. Harris?
Your Honor, I would argue that the intervention is appropriate and the motion to strike should be denied. Ms. Savage has referred to some cases that indicate that interventions filed close to trial or dismissal date are untimely. However, I will point to, in the interest of WGR number 0921000393CV, it is a case as recent as 2022 where a trial commenced and was recessed, delayed, many reasons, for 10 months, and for well over 10 months. And the interveners in that case intervened 10 months after the trial had commenced. So if that can be timely, this can be timely. An intervention that is out of Court of Appeals, 9th District, Beaumont.
Okay.
And the intervention in this case is not delaying permanency. The department, myself, CASA, at this point are all arguing that the children should remain where they are at, and that is what their permanency should involve. And so allowing the interveners to be a part of this will in fact let the court determine what is in the best interest of the children. Arguing that allowing them to be in the case would make it more complicated is not appropriate. They need to be here for the court to be able to determine what is in the children's best interest. And everybody said that it would make it more complicated without actually pointing to why it's more complicated. The only thing that really this petition does is just makes it more difficult for the mother and the father to show that their rights should not be terminated. Something else that should be considered when looking into why an intervention is filed when it is, the children were returned to this mother in October. So there was no reason for the interveners, the current interveners, to do anything, file anything, until after the children were removed and it was shown that the mother still was not making the appropriate changes in order to provide the children with a safe home.
What day was the intervention?
As far as whether it will be whether she's demonstrated that, whether the interveners have demonstrated that it would significantly impair the children's well-being. These children were removed from the mother's care as recently as December. She's tested positive this year since completing a drug treatment program last year. She's not even been permitted to be with the children unsupervised since they were removed in December. The children were removed from mom in December and placed back with the interveners. Therefore, mother should have been on notice that it was absolutely a possibility that they would be considered in the permanency plan for these children. Additionally, these interveners are not extended family or random individuals that weren't involved in this case previously. They've been here from the beginning. They've been attempting to get everything done for the children to be returned to mother, and she has not been able to do that. And that's why they have now filed at this point. So for those reasons, I think it's absolutely appropriate for the motion to strike to be denied.
What was the reason for surrendering the license?
That was, Your Honor, because it's kind of a convoluted story. I'll try to make it simple. They had another foster child placed in the home at that time that was under 18 months. They also were pregnant with their own biological child at that time. So placing these two children back into the home would have made it 3 children under the age of 18 months, which would have been fine, except that once she delivered her baby, then they would have been over the quota for what the state of Texas requires. Casa and myself attempted to work, and the foster parents attempted to work with the department and with their licensing agency to be able to come up with some creative solutions in order for the children to be placed there. But those requests were denied, and instead the department wanted to place the children in a shelter a day or two before Christmas and then remain there. So because the interveners had cared for the children for so long previously, because they were considered fictive kin at that point, because they had had such substantial past contact with the children, they made the decision to give up their license so that the children could be placed there. The other child was moved out of the home and the twins were moved in.
All right. There's some evidence that I will take in just a moment. Let me hear Ms. Swallow's arguments.
Judge, I would request that the motion to strike be denied. I can't say I agree that the intervener's presence is not in the best interest of these children. They have the best interest of these children in their heart and everything that they're doing. Ms. Savage made a statement that the children would be with the mother, but not for the interveners at this point. I don't think that's necessarily true. If the children were to be with the mother, then they should be with the mother, and they're not. They were removed in December for reasons that were contested. It was not just a voluntary, here, take my kids. I think that I do not believe that the intervener present creates a multiplication of issues at all. I believe the issues are still remain to be the same. I think that, in regards to, I'm not requesting that we extend the case beyond the dismissal date. When I entered into the case on behalf of my clients, the parties had been ordered to mediate this case back on February 20th per your court orders. They had still not scheduled the mediation when we entered this case on March 21st. To this date, the mediation still has not been scheduled. I gave over 22 options of availability between whatever date that was, a week or two ago, and now in this of dates and times where I could be available to mediate the case. I did not offer any type of event. So as far as delaying the proceedings or causing a multiplicity of issues, that is absolutely not true. If it's frightful or fearful that we have requested discovery, I'll withdraw that request, right? Like, I know we're late in I would just ask that we be able to exchange exhibits. So that's a normal thing that you do prior to trial. I would request that the court deny. As I previously stated, my clients do have standing to be in this lawsuit. They have standing to be in this lawsuit. These children were placed with them for 10 months. They were removed, and placed with the mom. Removed is probably the wrong word. They were placed with the mom under a monitored return for about 2 months, and then they went back to my clients. And if you look at the totality of the time period, it definitely meets standing under 102.00312. They also have substantial past contact with these children, so they have standing under that provision too. Standing is absolutely not an issue. They have standing to be here. The saying that this is causing a delay or they're untimely, my clients, when the children were placed back with the mother, they waited to see what was going to happen. They supported her. They took her formula and things, and they were there for her. They went to the children's birthday. Like, they were definite supports, and they were supporting mom. After the monitored return broke down, they waited until after the next hearing, which was on February 20th, to see, what was happening, to see how mom was doing, to see what the plan was going to be. They in no way wanted to do anything that was going to thwart mother's chances of getting these children back. However, at the last hearing, no changes were made to visitation. Actually, more court orders were put into place that definitely indicated that the plan was not a return at that time. And if that was the plan, then mom had an attorney that could have filed to have the children returned at that time. So it was shortly after that hearing that they contacted me, and I was able to jump into this lawsuit on their behalf.
Okay.
Your Honor, some rebuttal.
Briefly, yes.
A important distinguishing factor to Ms. Harris's case law that she pointed out is the legislature specifically changed the requirement of trial courts to end trial within 90 days of commencing, because they do not want children in limbo in these trials that are being recessed for months on end. Going back to the fact that this is untimely, it's going to delay prompt and permanent placement of these children. In regards to the trial court being able to strike this intervention, it absolutely has added more issues. Ms. Swallow pointed out that she gave 22 dates. She gave one half morning from the time of March 21st until before our trial date. All the other dates for mediation were after our trial setting, which is already scheduled for April 9th. If this intervention is to stand, they're saying, oh, we'll waive objection, we'll waive discovery, we'll waive this. There's nothing that's going to stop the department's case from dismissing automatically come May 12th. And then this intervention stands, and Ms. Bushman is going to be left with no representation. She's indigent, and it's going to be a matter of poverty versus money. And that's really what it'll come down to. It's going to be an entire Alfaro situation all over. So I do believe this is going to complicate the issues. I do believe it's untimely. They filed their intervention less than 60 days before dismissal. And there can say all this like, oh, we're not going to complicate anything. We're not causing any issues, but time will tell. They're already asking for a continuance of our dismissal of our trial, which is set for Tuesday. So I do believe that there's more than enough for this court to find that this petition and intervention should be stricken.
Okay, let me ask some questions. And in the interest of time, I just want the answers to the questions I'm asking only. And this one's for you, Ms. Savage. My understanding is that this case was initially extended under return and monitor statute, correct?
Yes, Your Honor.
Okay. And I'm not saying what I'm going to do. I haven't made a decision, but were the court to extend, what prohibition is there in statute or case law from extending under extraordinary circumstances?
I believe you can only use the extraordinary circumstances of the original dismissal deadline. I think the only extension that would be available at this point would be another monitored, possibly a transitional monitored, but I do not believe the extraordinary circumstances would be available given that we have had one extension under the monitored return.
That's the department's understanding as well, Your Honor.
Ms. Powell?
Yes, Your Honor.
As of today, is it safe to return the children back to Ms. Bushman?
I believe Ms. Bushman needs a little more time.
Being very concise, why do you believe that?
We just need more time to observe her with the children. Since they've been removed, there have been no overnights, no unsupervised visits. They've only been supervised.
What are the dangers or what are the concerns?
My concerns is that I'm concerned that she doesn't have that she continues to need support at the ready with both of the children. So my concern is that her support system is not strong enough, that she has to be prompted to do certain things, certain basic things. That's my concern, is whether or not she can handle two children alone.
What does she have to be prompted to do?
For instance, just don't pick the child up this way, or you need to bring snacks to visits, appropriate snacks to visits, things that are basic parenting. That's my real concern.
So is it your testimony? Is it your testimony today that the children cannot be returned to Ms. Bushman today because you feel they will be unsafe or at risk of abuse or neglect?
Possibly, yes.
Okay. As of today, has Ms. Bushman, and I know what I just asked you, but I want to make sure I hear this from you. Has she addressed all of the concerns that brought the children into care?
She has completed and addressed everything that we've asked her to.
Well, she's completed her service plan.
Yes.
Okay. When I just asked you if you had concerns, you said yes, and you stated some specific things. And when I asked you if the children would be in danger of abuse or neglect if they were returned to her, you said possibly yes. So I'm going to ask you again, has she fully addressed all of the concerns that brought the twins into care?
Not fully.
Okay. What does she need to do, and be very concise?
We need to observe her with more time with the children. She needs to understand that their health problems are serious and that she needs to listen to everything the doctors tell her and not to make decisions on pulling them off of medication or whatnot on her own. She needs to understand that she has not one but two small children, and it can be a lot for a person, and she has to rely on herself. She has to become more confident in caring for both children without needing continued support from outsiders, if that makes sense.
Does she have a reliable support system if she needs that help from outsiders?
She does have a support system in San Angelo, but the issue is the majority of that support system are trying to handle their own sobriety, their newly found sobriety. Most of her family is back here in San Antonio. And that's my fear, that she will become overwhelmed with both of the children on her own.
Do you believe that her being overwhelmed due to what you have classified as a questionable support system would subject the children to potential abuse or neglect?
Yes.
What is the permanency goal of the department / belong right now?
The permanency goal is still family reunification.
Why?
Because she continues to work her services. The more we add, she continues to work her services. It's just that one particular issue that we discussed, the support and her confidence.
Okay. Ms. Kyla Green, this is a procedural question. The department is aligned with the interveners as far as letting the intervention stand. The department at this time is not willing to return the children to Ms. Bushman as of today. Procedurally, how does the department / belong move forward with the looming dismissal date? I'm not saying I will, were the court to deny the motion to strike and allow the intervention to stand, what do you intend to do procedurally, and what does your timeline look like?
Your Honor, the dismissal date, I think we have about a month. Trial is scheduled for the 9th, and the dismissal date is May 12th, Your Honor. What we would do for that month is mediate, and I guess first request a reset of the trial within the dismissal date and mediate in that time with the interveners present.
And if you don't if your mediation is at an impasse with a looming dismissal date and trial, then what?
What is the department's intention at trial? If we were to go today, Your Honor, the department would be seeking termination.
And so the inference is that if that was the case, you would staff with your client regarding a change of the permanency goal?
Yes, Your Honor.
Okay. And you all have researched, specifically Ms. Kyla Green and Ms. Harris, since you talked about it in response to what Ms. Savage said, maybe it was Ms. Kyla Green and Ms. Savage, you've researched the procedure when it comes to extensions, because I know we've had this issue before, and it was a very big talking point for a while on which extension you can do first. And my understanding is that you cannot do an extraordinary circumstances first, but you can do the others first. and do the extraordinary circumstances second. Are you all sure in your summation of how that works?
My understanding is the opposite of what you just said, Your Honor, is that extraordinary circumstances come first, and there can only be an extension beyond that year and a half in a monitored return. It cannot be the other way around. I know that Ms. Savage spent a long time researching this issue and providing documentation that was used at trainings. So I think she's probably more appropriate to answer.
We've got an extraordinary circumstances extension. We've got a return and monitor, and there's a third, is there not?
The transitional, Your Honor. I know extraordinary only extends the original dismissal deadline, so that one is not available. The transitional is only available or is not available if you've extended under an extraordinary, but I don't believe
That's what I was thinking of. Okay.
But the first extension was a monitored return. So I don't believe you're prohibited from using that one because the statute only prohibits it specifically after an extraordinary circumstances, but we have not had that.
All
And
right.
Your Honor, I'm looking, Ms. Savage did create a great chart with a lot of case law that I rely upon. I'm looking for that to be able to provide that.
Yeah, I would enjoy reviewing that because I know it can get confusing. With the exception of that, there's really not anything else that I feel like I need to hear on any of these motions. But I've got a couple minutes if somebody feels like there's some evidence that they're going to pull out that is going to shed some light on something that I'm not already aware of. Nothing redundant.
Nothing evidence-wise, Your Honor. I just want to point out that we are set for trial, but we're set for a very short window. And obviously this is going to be contested, and it's necessarily going to need to be reset anyway.
You're talking about Tuesday.
Yes.
Yeah, I can't imagine anything that you all would get done on Tuesday, either way in this situation, other than having to seek termination. And it seems to me like there's still a lot of dust in the air that needs to settle. Ms. Swallow, well, let me go first with Ms. Savage. Ms. Savage, I think you've argued everything that you're going to argue on your motion to strike. You've also got an authorization to place. I'll give you a couple minutes if you want to present anything, an argument or some very brief evidence. I mean, I'm very familiar with this case. I've made several orders. I've looked through my notes. Is there anything else that you can add that you think I might not be aware of?
Yes, Your Honor, if I can briefly call Ms. Bushman, there's been, just so she can enlighten the court on, the things she was doing with the children and taking them to the doctors while she had them.
Okay, make it quick.
Yes, Your Honor. Ms. Bushman, you've heard the arguments from counsel today. The children were placed with you in October through December. During that time, would you take the children to the doctor, and were you keeping up with their providers?
Yes. The first time I took them to the doctor.
Well, hang on. Let's not. We're going to be here way too long. The answer was a yes or no. You answered yes. Ask your next question, Ms. Savage.
Did you have a swallow study done on Jameson?
Yes, I did.
And did you follow that doctor's recommendations following that swallow study?
Yes.
If this court were to give you more time or unsupervised time with your children, would you follow doctor's recommendations for the children?
Yes, of course.
Are you asking the court to give you some unsupervised time with the children?
Yes.
Has it been difficult as far as having visitation with the children when they went back to care because of the distance that you are from the kids?
Yes.
And has that limited your in-person visitation with the children?
Yes.
Given Ona's concerns of you with the kids, do you think it would be appropriate for you to have more time to show that you can meet the children's needs?
Yes.
Okay. And before you took children off of, any of their medications or thickeners or anything, were you seeing the children's doctors and taking their advice in?
Yes.
Okay. Have you complied with every request that the department has asked of you?
Yes.
And will you continue to do so?
Yes.
And you have appropriate housing for the children at this time?
I do.
And you do have transportation for them as well?
I do.
And you do have a daycare identified for them as well?
I do.
And you're working?
Yes.
And you've provided those pay stubs to the department?
Yes.
As well as a copy of your lease?
Yes.
I'll pass the witness, Your Honor.
Pellegrini, direct.
Thank you, Your Honor. Ms. Fishman, thank you. Ms. Fishman, you currently work some nights, isn't that correct?
I do, but I have been. Okay. Yes.
And you work 2 part-time jobs, one where you work nights and then one at Schlotsky's during the day. Okay, and you need, I'm sorry?
I work at Slotsky's at night and the other one during the morning.
Okay, and you need those, you need both of those incomes to make ends meet, is that correct?
No, ma'am.
So it's not true that you have about $300 in excess of your budget at the end at the end of the month?
That was just with Slotsky's.
Okay. So you work at Schlotsky's, you work part-time at night?
At Slotsky's, yes.
Okay, and you're saying that you could care for your 2 children
With
by
just
working
one,
part-time at Schlotsky's at night?
or with the job in the morning.
Okay, so you would have to significantly change your employment issues or your employment schedule in order to have your children, were they to be returned today.
Right.
Okay, and you would have to rebudget since currently you work 2 jobs, not just one.
I mean, I may have more money now. I mean, so
you would have to rebudget if you basically cut your income in half.
no, because that budget was only with the Miss Slotsky's one. That was before I started working in Moretta.
Okay, so you haven't created a budget again, given that you now have 2 jobs.
Right.
Okay, have you been paying child support to the foster family?
No.
Have you been paying child support to the department?
No. I have not been ordered to, so I have not, no. But I do provide diapers and wipes and stuff on the visits when I go.
Okay, and the swallow study and the recommendations or orders by the doctor for thickening formula, you stopped using the thickening formula on the kids, isn't that right?
Yes, ma'am. But Dr. Riley told me.
You decided that the children didn't need it.
Dr. Riley told me that if they could drink regular water, that they could drink formula without thickener.
I didn't hear the objection, Your Honor.
I object to hearsay. Your Honor, it's a statement from medical diagnosis.
Repeat the answer or repeat the question.
The question, Your Honor, was despite the medical recommendations and orders by the doctor to keep the children on the thickening formula, Ms. Bushman took them off.
And Ms. Savage, your argument is that it's a medical diagnosis?
It was, yes, she was giving the statement, the treatment diagnosis of the doctor.
And it's hearsay within hearsay. Sustained.
I have nothing further, Your Honor.
Ms. Pearsall, do you have any questions?
I do not, Your Honor. Thank you.
Ms. Savage. Oh, excuse me. It's your witness, Ms. Harris.
Ma'am, do you have a car that's working?
Yes, ma'am.
Is that how you get around?
Yes, ma'am.
When did you get that? When were you able to start using that car?
I got it all the way legal, I believe last week. I'm not exactly sure the date.
You have insurance on it?
Yes, ma'am.
And how many doctor's appointments have you been to since the children were re-removed in December?
How many doctor's appointments have I been to?
Yes, ma'am.
For myself?
No, for the children.
They're in Kerrville. How am I supposed
Ma'am, how many doctor's appointments have you been to?
None, because there was a telehealth.
Okay, thank you. Objection, Your Honor, non-responsive.
Sustained.
Did you get a swallow study done on Jasmine?
I did not, because it was scheduled for
That's
after
yes
they
or
were
no, ma'am.
removed.
Yes or no? Did you
No.
get one scheduled for her? Do you still
Yes, I
smoke
have
or vape?
I have cut down drastically on how much I vape, and I do not smoke cigarettes anymore.
Have you been told by anyone that you tested positive on any drug tests this year?
Just a nail test, and that one goes back 18 months.
Did you take a class on what nail tests do?
No, but I asked the people that do the
Hold
drug
on,
testing.
did you take a class on it, ma'am? Did you take a class on it?
No.
Are you in any way employed in any field that reads drug tests or nails tests?
Are you?
No, that's not how
I'm
this
sorry.
works. I've heard enough. I've heard enough. We've got some procedural issues here that we need to work out. The motion for ATP is denied. The motion to strike is denied. Or monitor return, excuse me. Was there any? No, there wasn't. It was for monitor return. That's what I need to talk about. So let me correct myself. I'm denying the motion to strike. The problem that we have is that there is an objection to the associate judge file. If you're going to try to get a trial setting before May 12th with the district court, you need to start trying to get that today. Because the only way that you're going to get an extension on this case is if the court grants a monitored return, and I'm not going to grant that today. Like I said, prior to this hearing, prior to the testimony, I'm very familiar with this case. I'm very familiar with the issues in this case. I've been involved in it from the get-go. And it's clear to me from Ms. Powell's testimony and from the little bit of testimony, but it was enough. I heard from Ms. Bushman that we've still got concerns, and I'm not going to return the children today. So where we stand is the interveners are going to remain in this case at this point. The monitored return is not getting granted today. Father's not even here. And there's an objection to the associate judge and a motion for continuance of the trial date. I don't have a problem extending the trial date in order to allow you all to get in front of the district judge. But it's going to be difficult. It's not going to be easy to get a setting. So this is what I'm going to do. I'm going to abate my ruling on the motion for continuance. I'm going to allow you all to reach out to the DJ about available trial settings so you can commence your trial after you've had the chance to mediate, because I'm ordering you all to mediation. I don't know what else I can do today. I don't think I can do anything else today.
Good.
Yes.
Is it possible to give us a trial setting? And I will talk to my clients about the objection.
I would prefer you talk to your client about the objection first before we start rearranging schedules to figure out a trial date.
Okay.
Let Miss Greenlee know something by tomorrow.
Okay.
And I think that's as far as I can go today. And I want you all to talk about Miss Swallow. I think it's wise to exchange exhibits rather than try to get discovery. It's not the discovery is not even timely at this point in time. I don't think it was propounded 60 days before trial, and I don't think you're going to get that with this looming dismissal date and my denial of the monitored return. So talk about that. Find out if you can get a setting with the DJ, and find out if your client's willing to waive the objection. And if she is, then we'll look at dates. If she's not, then you've got to get with Judge Kindred's coordinator and find out if they can get a visiting judge in there to commence this trial prior to the dismissal date. That'll be the order of the court. Anything I failed to address?
No, Your Honor.
Okay.